Sorry, my mic is off. Commissioner Malema.
Thank you very much, CJ, and good afternoon, JP.
Good afternoon, Commissioner Malema.
I just want to understand what do you mean by South Africans are gullible?
What I mean is they tend to believe anything and everything they hear.
But what is
Not
that
all
based
of them, not all of them. Yes.
Oh, because I just heard a sweeping statement that South Africans are gullible.
No, not all of them, sorry.
Okay. Now, there's a crisis there of 170,000 maintenance applications which are not being resolved. And not so long ago, I think the Department of Justice was launching one of the programs to hand over the defaulters to credit bureaus so that they can be blacklisted. But you can't blacklist people who are not there. They are stuck there by the maintenance courts. And in this case, the latest was 170,000. What can be done to resolve that issue? Because it means there are more than 170,000 children, African children who are starving, who are going through hunger. And the court is not intervening speedily to ensure that it alleviates that hunger and poverty amongst African children. Thanks.
Thank you, Commissioner Malema. That's a very worrying situation. And you are conservative by saying 170,000 children. It could be double. Now, look, the executive, the maintenance calls fall under the executive branch of government. I think if they consult with us, we may find ways of saying, how do you, if it's capacity related in terms of processing these claims, how do you increase capacity over a short period and process these claims as quickly as possible? You're correct that you can't just hand people over to the credit bureau. Some of them may not be aware, right? So that's one aspect that can be done. Increase the capacity of the people who process these claims. But Commissioner Malema, you and me know this is an age-old problem. And probably it's an incident of the patriarchal society issue that Commissioner Pillay mentioned, because mostly it's women that come and ask for maintenance. They are treated in this way. It's something that needs to be addressed frontally, right? As I say, when I tried, I heard on 702 driving to work that there was a big problem in the Randburg maintenance court. So when I phoned the chief magistrate to say, hey, there is this issue, and then the response I received, that was a few years ago, probably 4 or 5 years ago. The response I got from the chief magistrate was, look, maintenance officers don't fall under the courts. They don't fall under the judiciary. I said, but that's strange. They are located in the court. You as the head of the court should have oversight over them. I said, no, I don't, right? I think whether it's the family advocate or who has jurisdiction over them. And I said, no. This must be addressed, right? But I remember talking to the DG to say, look, we need to do something about this, because if it's publicized on radio, we've heard it. Having heard it, what have we done about it, right? It's away from me. But I suppose as DCJ, Commissioner Malema, nothing prevents me from saying to the Chief Justice, this affects a large component of South African society. We need to engage the executive in coming with an effective way of ensuring that there is a credible and effective system of dealing with these things and making sure there are no backlogs that are created. That's all I can say, Commissioner Malema. I acknowledge the problem.
Thank you, Commissioner Malema. Commissioner Baloyi.
Thank you, CJ. Good afternoon, JP.
Good afternoon, Commissioner Baloyi.
Yes. The first question is about the the compulsory mediation, and I'm not asking you to speak to the matter that is presently before court pending, but I want to talk about the general concept itself. If you were to be appointed as DCJ, I would assume, and assuming that the court clears your directive and accepts that it is permissible, that the court can order that there should be mediation. I'm assuming that. One would assume or expect that if you appointed DCJ, this is a project that you would try to get buy-in for, to be distributed or to be spread across the country from the CJ and from the other heads of courts. Now, perhaps if you would speak to why this idea, this innovation, but more importantly, how would you ensure that this does not become another administrative step, another annoying administrative step in the process for matters to be heard? And I ask this question because of experience of mediation under the LRA, where often parties rock up without any meaningful intention for matters to be resolved at mediation. What do you say would have to happen for this to be a successful project that serves its intended purpose? And its intended purpose being what?
Thank you, Commissioner Baloyi. I think this step needs to be viewed as a Gauteng-only initiation that seeks to address a particular problem in Gauteng. And when I say that, and the leadership, it's an inclusive project, by the way, it's not only mine. The two DJPs and some judges in the division are part of the team that's behind this project. Our view was, let's arrest this runaway train of a wait of 5, 6, 7 years for a trial date. Let's introduce something that will not deprive people of their access to court, right? But of saying, because of what happens when you eventually land in court, we think you can get justice quicker if you go that route. That's what it is, just a divisional measure, initiative to address the current situation. The long-term solution lies in what that subcommittee of the Law Reform Commission has published, a mediation bill, which targets part of this area that I have. So in terms of long-term longevity, of the directive, I don't think it will last a long time, right? But it will apply for as long as we want to assist litigants come to court quicker for their matters. That's the objective behind the directive, to say you are in 2025, you get a date in 2031. That's inimical to access to justice in the constitutional sense. So what do you do as a head of court? You find another way to ensure that those matters that genuinely require a judicial engagement are given earlier dates, when you've removed the chaff that's simply clogging the roll, simply because you're waiting for the trial date to come and then you'll meaningfully engage each other then. The directive simply says engage each other earlier and resolve your disputes and your differences earlier. And that matter will not come back to the court. Other matters that are deserving of judicial attention will then go on. So I think that answers both your questions in terms of longevity. The bill that's been published, I don't know when it will happen, but it's there. but the directive is not of a permanent nature. It is meant to arrest the situation that we have, right? And perhaps if we get more judicial posts, we'll find a way of ensuring that we ease its effect.
I guess the main part of my question really, JP, was how do you make this an effectual step in the litigation process, avoiding that parties go to mediation because they are compelled to go to mediation, but they just present without any meaningful intention to get matters resolved at mediation, and thus turn this innovation into just another step that must be ticked. Have you thought about how you make this to be an effective step?
Well, thanks for the follow-up question, Commissioner Malloy. That's why we've said the report we get of the engagement with the process should tell us that there was meaningful engagement between the two parties. And that is, if there was no meaningful engagement, then we've created a shortened step as to if this matter was on the trial roll in January 2026, but you've gone through the hoops, you are in August, and you've had no meaningful engagement, no meaningful response to your request, we've provided a route for you to go to the TIC court or the SIU court where you can get the relief you would get in 7 years' time. So we're making it effectual in that sense.
Thank you. CJ, the second is more the work of the committee, the objections. I don't know if this is the point to put it.
Yeah.
Commissioner Hassan had already touched on one aspect of it.
This would be the right time, but before you get to it, Commissioner Balo, you may just follow up on your first question. JP Mlambo, in your response, you say this directive is only, is divisional.
Yeah, that is correct.
It's meant only for the purposes of your division. But as you and I know, the challenge is not confined to Gauteng. There are a few other divisions that are afflicted by the same problem. The position of DCJ is a national one. You would not just be minding one division. If you are appointed, would you push for the implementation of this directive, assuming that it passes it passes through the hopes of the litigation and passes constitutional muster, because one suspects it will go to the Constitutional Court finally, where it started, by the way. Would you push for its implementation across the board?
Well, CJ, I think it's a catch-22 situation.
In the short term?
In the short term, probably, because I know I've seen one court order from Limpopo directing people to mediation. I've seen another one, I think two, from Mpumalanga, directing parties to mediation. So you're correct, CJ. It's a national problem. It's more acutely felt, however, in Gauteng, which is what drove us in the division to issue it. So in the short term, probably, yes, we would push for it to be of national effect. But I think the chair of the Law Reform Commission has written to the heads of courts about our view to the mediation bill, right? So it has our support. I would rather want to see a situation where that mediation bill process is expedited, so that this piecemeal treatment of this national problem is arrested by an act of general application by way of the Mediation Act when it comes. But yes, correctly, were I to be appointed, I would request the Chief Justice to get the heads of courts to wrap their heads around and see how we can extend the ambit of a directive of this nature, or even improve it to apply to other divisions. I would do that, yes.
Yeah. Well, Minister Kupai and a few parliamentarians are here regarding the fate of the bill. So one hopes they're listening and, understand the problem which the courts face in this regard. You may proceed.
CJ, can I please follow up before?
Yes, Prof.
Yes. Thank you very much, CJ. JP, I had a chance of looking at the discussion paper on alternative dispute resolution, South African Mediation Act for South Africa, that tries to provide an overview of how the South African law commission actually is thinking about where the role of mediation in South Africa. One thing that I do not see coming out, it is while they kind of like advocate for mediation and try to explain the importance of mediation as an alternative dispute resolution, the issue of training of mediators doesn't come out very strongly. And I think one can tie that also with the proposal of how we ought to deal with mediation within the Gauteng division. That yes, this is a positive step, but it doesn't seem like there is much emphasis on the training of mediators. Because when you have spaces like family law, there is training going on there, labor law, there is training going on there. But when you are dealing with other areas, which might be a little bit more complex, most of which generally are dealt with arbitrations and all those kind of things, how should we approach this innovation in line with the necessary training that is needed to ensure that the system operates? And I think that is the discussion that we are not having.
Commissioner Marumo Achai, thank you very much for the question. I want to admit, we didn't focus on training when we issued this mediation, because if you see what we are reliant on in terms of the mediation services are the mediation bodies that are there. But this issue of training has now come back forcefully. But you see, we don't have the resources as the judiciary to train mediators, right? And it's something that we need to think about how it can be done, because we've received a number of proposals about how ordinary members of the bar or the legal profession can be trained and actually assist in doing this work. So upfront, as I say, we didn't think of it because with that, we'll utilize the existing mediation bodies, right? And that's why there's a schedule that talks about them. And we have to amend and make sure, clarify what role these mediation bodies are. So I take the point. We didn't think about training, but yes, mediation training is important if one wants to see it successful. I agree with you.
Thank you, JP. Thank you, CJ.